Good afternoon, everyone, and very welcome to our Life Sciences seminar of today. During the coming hour, we will gladly navigate you through mergers and acquisitions in the life sciences sector, and we will inform you about some insights, but of course also some pitfalls to avoid during the M&A process. During this webinar, you will see and hear my colleagues Richard Liu, Associate Corporate Law, Pauline Heetjes, Associate IP Law, and myself, Mieke Danis, Associate Employment Law. Given the fact that we only have 1 hour to guide you through the structuring of different deals in the M&A world and to briefly explain the life cycle starting at the due diligence process over signing to closing of a deal, we kindly invite you to send us any question you may have in the chat box of this Teams meeting. Should there be any time left, we will answer some of your questions to the best of our abilities. But without further ado, I now give the floor to Richard.
Thank you, Mieke. So, start off with showcasing some recent activity in the M&A dealings in the life sciences sector. The dynamic here is clear. Biotech companies are in need of cash, whilst the established bigger players are looking to expand their portfolio. Here's some additional headliners that are a bit more local. I believe this shows enough how today's topic is definitely relevant. Acquisition of a business, M&A, deal making, transactions, all very sexy words we use to sound a bit more professional and business savvy. But let's not forget that it all boils down to, from a legal perspective, to a sale purchase agreement. Under Belgian law, you know that a sale purchase comes into fruition when parties agree on two things, namely the purchase price and the object of the sale. These are going to be the central points that we need to continue thinking about throughout this webinar. Ownership is transferred by consensus of the parties, or in Latin we say solo consensu, the moment when both parties agree on the two things, purchase price and object of the sale. For further context, we have on this slide some statistics related to M&A deal values here in Belgium. As you can determine from the slides, I highlighted specifically the healthcare and pharmaceutical and biotech sectors, and you will see that the majority of the deal value in this sector relates to deals above 100 million euros. Something to keep in mind for later in this webinar when we deal into some specific things. Now, onto the second aspect, the legal object of the sale. What is it that we are buying here? Cutting to the chase, key asset that we want is the intellectual property regarding the technology, science that we are interested in. Sometimes that alone is not enough. We are also interested in the smart people behind the IP who make it all possible. Also other people with expertise and know-how, knowing how to get the product to the market, supply chain experts, and so on. You can see on this slide that I'm limiting myself to very basic buzzword terms because that's where my expertise as a mere corporate lawyer ends. And yeah, to be more specific on what exactly is that we are interested in, usually in this life sciences sector of M&A dealings, I am handing it over to my associate of the IP team, Pauline.
Good afternoon, everyone. Before diving into the importance of IP, I will give a high-level overview of the most important IP rights in a life sciences context and their object and scope of protection for those of you that might be less familiar with IP. The check marks on the slides indicate whether the right in question needs to be registered in the official registers for protection or not. As you will likely know, one of the most crucial forms of intellectual property in the life sciences are, of course, patents. A patent grants its holder an exclusive right to the invention for 20 years, which can be extended with supplementary protection certificates, or SPCs, for pharmaceutical products and pesticides that have been authorized by regulatory authorities. SPCs aim to offset the loss of patent protection for pharmaceutical products and pesticides that occurs due to the compulsory lengthy testing and clinical trials these products require prior to obtaining regulatory marketing approval. Plant variety rights, or PVRs, are frequent in the agri-food sector. The holder of a plant variety right receives exclusive control over the propagating and harvested material of his protected variety. A PVR is valid for a period of 25 to 30 years, depending on the species. Trademarks are another key aspect of intellectual property in the life sciences sector. They protect brand names and logos associated with products in this industry. This branding protection ensures brand recognition and prevents competitors from using similar branding to deceive consumers, initially for 10 years, but indefinitely renewable. Design rights grant exclusive rights to the visual appearance of a product during 5 to 20 years. This is the case for registered design rights. In the EU, we also have non-registered design rights providing limited protection during 3 years. In life sciences, design rights serve to protect the unique designs of medical devices or even pharmaceutical packaging. At first glance, copyrights might seem less important for life sciences. Their importance should, however, not be underestimated. A biotech company, for example, can rely on copyrights to protect its proprietary software and data analysis tools essential for drug discovery, and this for a very long protection term and without having to fulfill registration formalities. Trade secrets are not IP rights sensu stricto, reason why we drew this line on the slides. But trade secrets are pivotal in life sciences as they protect any information that is secret and commercially valuable from unauthorized disclosure and use, for example, research methodologies or manufacturing processes. Last, but very important bit of background concerns regulatory exclusivity. Data exclusivity is a form of exclusivity right for medicinal products in Europe, and market exclusivity is a related form of additional protection. These two rights are in addition to any granted patent exclusivity right covering a medicinal product and are not IP rights sensu stricto. RDP is an instrument that is intended to protect the content of the regulatory filing an originator company makes to obtain a marketing authorization. To that end, it must submit extensive data showing the efficacy and safety of the medicine, usually through clinical and preclinical trials. An innovator company enjoys a period of data exclusivity of 8 years after market authorization grant, during which their preclinical and clinical trials data may not be referenced in regulatory filings of another company, which will typically be, of course, a generic company, for the same drug substance. As from the expiry of the RDP period, the reference medicinal product enjoys another 2 years of market exclusivity. It's possible to obtain another additional year of market protection if, during the 8 years RDP period, the originator has obtained a marketing authorization for one or more new therapeutic indications which are held to bring a significant clinical benefit in comparison with existing therapies. If, however, a new indication for a well-established substance is found following clinical and preclinical trials, there is an additional year of regular data protection. Now, after this theoretical part, let's delve deeper into the importance of IP for life sciences and how these different IP rights interact in this specific sector. The most significant factors bearing on market exclusivity for pharmaceutical companies and agri-food pesticide companies are patents and SPCs. Beyond traditional IP, regulatory exclusivity periods play a key role in the market exclusivity of pharmaceutical companies. Plant variety rights, in turn, are also essential for protecting innovations in the agri-food sector. In the highly specialized life sciences field, the aforementioned patent and plant variety rights will contribute to the reputation of innovators. Trademarks, in turn, protect said carefully built reputation and ensure quality assurance to customers. Of course, the aforementioned IP rights serve as a competitive advantage by granting exclusive rights to their owner or protecting their reputation. However, when pursuing IP rights is not feasible for the company due to financial reasons or because the conditions for IP protection are not met, trade secrets can also give the company a competitive advantage by ensuring their innovative discoveries remain confidential. Last, patents, SPCs, and regulatory data protection have a direct regulatory impact by potentially avoiding mandatory price increases for certain products and therefore also impacting their value. I will now happily give the floor back to Richard, who will tell you how to structure the deal.
Now we're getting to deeper into some basic M&A matters that are nevertheless important, as these are the building blocks for the transaction. So for the purpose of this webinar, we would like to disclaim that we are only covering situations where a buyer will acquire 100% of a business. We know it happens from time to time in the life science sector, where we have joint venture situations with post-transaction collaboration agreements, shareholders agreements, but that could be a topic for our next webinar. We would go way too deep within the interest of time. So now let's talk about deal structuring. We know that no acquisition is the same. We all know that. Nevertheless, we find it important to briefly go over the different transaction types that we can have in Belgium, as the points for attention vary for each category. So the importance of choosing the right deal structure is not to be underestimated. It's a very important choice. It should be one of the first points to be clarified at the very start of negotiations, because this affects the later processes of the deal, such as the due diligence process, where you would look at documentation and evaluate the information that you receive differently. It also changes in transaction documentation. For instance, in a share deal, what you're buying is the shares, so the purchase agreement will be called a share purchase agreement. Whilst in an asset deal, this could take many other forms, such as an asset purchase agreement, but it can also be a general business transfer agreement. Contract parties are also different for both transactions, because what you're trying to do with an asset deal here is that you're trying to acquire the business directly. So the seller will actually be the target company itself. Whilst in the share deal, you are trying to acquire the business indirectly by becoming the new owner of the company that owns the business itself. And that's why the sellers here are the shareholders of said target company. A bit more about the object of the sale that we have with asset deals. These could range from the entirety of a business or business division, but only a few assets, such as the intellectual property rights. That could be a specific list of sorts that you're interested in, or a specific clinical data that you want, or maybe simply just a number of related contracts, or a list of client portfolio that you would like to incorporate into your own supply chain. Everything is possible. But this has an impact on how protected the parties are under Belgian civil law. In this perspective, I would like to point out that there's no exact typical structure that is favored in the life science sector. It is all about the question, knowing as a purchaser, what do you want to acquire? Is there an interest to buy everything and you don't care about potential unknown liabilities that might come with the company? Then you acquire the whole company. But if you already know that you don't want to buy everything of the business, then you can limit it to certain assets that you wish to acquire. If there's no particular reason that you only want a specific set of assets, then in this case, the share deal would often be the most easy option to consider. You know that with a share deal, there is no cherry picking possible. As said, you have to buy everything. However, it could happen that you already know what part of the company you do not want to buy. So in this case, before closing, it's possible to have some carve-outs. Here comes into play the third category, which is actually not a separate category because it's a legally organized way of transaction. That's actually a variation of the share deal and asset deal, but it's following legally prescribed formalities that you need to follow, with all the benefits to it being that once you completely comply with the procedure, you would be able to enforce it to all third parties that this transaction happened and that ownership has been transferred. Lastly, there are some small tax considerations as well. For the sake of completeness, I have to mention when choosing the deal structure, but without going too much into details, that's something to keep in mind because this is not within the scope of today's webinar. So that's it for deal structuring. Move on to typical timeline that we could have in an acquisition process. So it is noted that the average duration of a deal in Belgium takes about 8 to 9 months. The deal in the life sciences is actually no exception to that. And then you have the typical steps that you have at the beginning. Parties conclude a non-disclosure agreement. They're starting their negotiations, business talks, but they don't want anything to leak out, so everything is highly confidential. Once you're more comfortable with what you have been discussing, once you already have some key deal terms in place, and you are more clear that you might want to move on with this potential transaction, usually a letter of intent or an LOI is signed between the parties. Here to pay attention that you're not too eager yet to agree on too many points, because as said earlier, the sale comes into being when parties agree on price and the object of the sale. So usually in an LOI, you have many clauses that are binding, but also clauses that are non-binding. And now we get to the deeper part, into the heart of the transaction, where parties start to exchange more information so the purchaser can confirm its own assumptions regarding the business it wants to acquire, and the seller is trying to convince the purchaser that, you know, the business is all good and what you're buying here is definitely what you want. So this is a due diligence process where in the life science sector, we will pay attention to more specific things than we would do in different transactions in different sectors. In general, just to close off, we won't focus too much on closing or fulfillment of conditions precedents. These are typical standard that you can find in any sector in case of bigger, larger transactions, merger clearance, or other kinds of regulatory approvals. So that would not be the focus of today's webinar. So moving on to a bit more on the due diligence phase. So a deal cannot be completed overnight. It will happen in multiple steps. And most of you are familiar with the due diligence phase. This is a crucial step that cannot be skipped. The buyer wishes to confirm its assumptions regarding the potential acquisition, and here the seller cooperates to provide all this information and documents regarding the business. So it's not only limited to reviewing legal information. This could also cover financial, tax, and technical aspects regarding the business. In bigger transactions, typically, such as in the life sciences sector, a potential buyer usually assembles a multidisciplinary team to conduct the DD. You have lawyers, tax consultants on it, other financial advisors, but you can also have a team of like specialized experts in specific technology here. So we can imagine, especially here in the life science sector, the technical experts are hired to review the life sciences related parts. And yeah, most obviously here, what's definitely important, the asset that we want to review the best is the intellectual property, and which is also the focus of today's life sciences session. So therefore, I am very delighted to give the floor again to my colleague Pauline, who will cover some important IP aspects during due diligence.
Thank you, Richard. As said in the beginning, it's clear that IP plays a very important role and is often the crown jewel, which is a driving force behind M&A activity. A general goal of the target should therefore be to have a clear IP strategy and portfolio from the very beginning. Indeed, given its value and strategic importance, buyer will carry out a careful due diligence of the target's IP portfolio to ensure it gets what it pays for. So, a first crucial step in an IP due diligence process is, of course, identifying the target's IP and whether the target does indeed own the IP it says or thinks it owns. An important part of the DD process will therefore focus on the target's IP ownership and chain of title. For that, buyer will have to proceed to a careful examination that will be different depending on whether the IP concerned is non-registered IP or registered IP, which is the IP with the checkboxes at the beginning of my slides. Buyer should start by identifying the various types of non-registered IP that may exist within the target company, such as trade secrets or copyright. For that, buyer will request information and documents to understand how the target's IP has been developed or acquired, including whether the target engaged consultants or independent contractors to develop IP, or whether the target's employees did all of the developments in-house. Next, buyer will examine all relevant agreements, such as employment, confidentiality, collaboration, and licensing agreements, which may contain information about non-registered IP and any restrictions on its ownership, use, or disclosure. For the registered IP, on the other hand, it will be important for buyer to check the public registers. The information contained in such official public registers will be very valuable in the DD process, as it will allow buyer to check whether the IP target says it owns is indeed registered and whether such registration is in the name of the company. Such public registers will also have their importance after the closing of the deal, to which we will come back at the end. If target is an originator company, thorough examination of the marketing authorization database will also be essential during the DD process, as this will confirm the exclusivity and protection granted to target products and the duration thereof. Longer exclusivity periods provide, of course, a competitive edge. Now let's talk about the typical pitfall, the IP assignments. Problems for life sciences companies are commonly encountered where research has been conducted by inventors with multiple affiliations. In these cases, intellectual property rights may not be properly vested in the apparent owner. For example, when target's product pipeline has been driven by the work of a researcher who is engaged on a part-time consultancy basis, which allows him to continue his research as a leading university. Another common pitfall is the lack of proper assignment clauses in the contracts of the target company's employees or management. It is therefore crucial to ensure that employees involved in the development of IP are subject to valid assignment agreements, effectively and fully assigning their rights to the target. If this is not the case, separate assignment agreements should be concluded in the course of the transaction. Further complexity can arise where research has been undertaken in collaboration with third parties. Collaborations in various forms are very common in the life sciences industry. Such arrangements can give rise to a range of pitfalls, including the ownership and allocation of rights. This can lead to limitations on targets' rights to license or assign the resulting intellectual property. For example, it is not uncommon for collaboration agreements to refer to arising intellectual property as being jointly owned, without defining the implications of such joint ownership. Under Belgian law, this will mean that the co-owners are not allowed to assign or license the arising patent without the prior consent of all co-owners. Last, to finish off with some other points for consideration, will particularly be to verify the freedom to operate and the trade secret protection. Particularly for product candidates that have not yet reached the market, it will be important to assess the risk that the product manufacture or commercialization might infringe a third party's intellectual property rights. Although it may not be practical to conduct fulsome FTO analyses for each of the target company's products and product candidates, such analyses may be warranted for the most important products or candidates. Last, to the extent that the target relies on trade secret protection, the strength of its security and confidentiality procedures for safeguarding the secrecy of those trade secrets should be reviewed, such as the existence of NDAs. Now that we know what to pay attention to, we will of course need to do something with our findings. Richard will tell you all about it.
Thank you, Pauline. After the DD phase, it is time now to have our findings reflected in the purchase agreement. To not overcomplicate things, we will continue for now in the context of a share deal. So a share purchase agreement will be drafted here. Most of you are probably familiar with the general sequence of SPAs. You know that the reps and warranties are usually set out in detail as an annex to the SPA. But as we are coming off fresh from a discussion regarding due diligence, let's first discuss the reps and warranties. So just a few general things on reps and warranties. Most of you probably know what these are, but to put it simply, after the purchaser has conducted its due diligence, it wants to have its findings reflected in a list of reps and warranties. So these are a list of statements, representations made by the seller in the SPA regarding the target's business. It makes sense, of course, that this list, if this list is longer, the purchaser will be more protected because the seller will have to owe up to more things being true, accurate, and correct. Just a small point, you all know why is this important typically in a share deal. It's because the object of the sale here is the shares and not the underlying business of the company. So under Belgian civil law, the seller's guarantee obligations will be limited to guaranteeing that there are no defects to the shares and safeguard for any other encumbrances on the shares. And for shares, it will only be limited to the fact to see if it's pledged or not, or if there was proper ownership from the seller when transferring the shares. So in this range, the protection for the purchaser is limited. So this is why we have an elaborate long list of reps and warranties. So the main point that I want to make here, to keep this part briefly, is that this is a typical list of items that are included in the reps and warranties list and can cover quite a lot of topics. Point here to be made is that transactions in different sectors, certain reps and warranties will be more elaborate than others. So, for example, if you have a transaction to acquire a hotel business, you could be very certain that real estate and environment will be a lot more fleshed out than, for instance, IP, which will be more the case for life sciences deals. Now, putting it into action, I know that the determination whether or not there being a breach is a bit more complicated in practice, but especially if, for example, a data room disclosure clause is provided, but let's make abstraction of that for now. The general idea here is that the purchaser wants the seller to agree to this list of statements. So the purchaser will be protected in case any of the reps and warranties would be untrue, incorrect, inaccurate, or incomplete, depending on how many words you manage to flip into the SPA. So in a simplified scenario, when the reps and warranties are breached, the purchaser can hold the seller liable for this. To put this into focus, we have a short example of what a typical negotiated representation could look like regarding intellectual property rights. So you want the full IP ownership to be with the target, but of course, you've been into the data room, you've seen there are probably some third-party licenses or third-party rights granted to other parties. So you will obviously negotiate, okay, except for these agreements that I saw. Life would otherwise be a bit too easy if you could just simply get the seller to agree with, hey, everything is okay. I assume that no seller would simply accept that. So that was a quick run on reps and warranties. This is typically, in general, just not very different than from any other sector, but just know that certain parts of the reps and warranties will definitely be more elaborate than you would have in different sectors. So next, getting back to the thing we mentioned during the introduction, I would like to go back to the whole deal value amount thing, because here with the reps and warranties, especially in larger deals, you want to keep the risks as low as possible. Concept of a warranty and indemnity insurance is that the insurance to shift the risk of any breach to a third party, here namely the insurer. So this concept is not new, but specifically in Belgium, this has been increased in use during the latest years. So this comes back because it's only interesting in higher value deals, because the cost of getting a warranty and indemnity insurance is relatively high, because it's between 1% and 2% of the insured amount, with usually a minimum premium of around 75,000 euros. Then there are other considerations to take into account regarding how to complete the data room and due diligence. But in principle, the insurance will cover matters after proper due diligence only that were unknown to the buyer, and disclosed matters are in principle always excluded. But here it's actually very important that you properly populate the data room, otherwise the insurer won't want to go in bed with you. So moving on, so far we've been talking about what we are trying to buy, the object of the sale. But as mentioned at the beginning, for a sale to materialize, we also need to agree on the price, as it is a constitutive element of the sale as well. So from a legal point of view, the parties are entirely free to determine the structure of the purchase price and its payment modalities. It's only important that the price is determined or can be determined. So this could get a bit more complicated in practice, and there are some aspects that are interesting in life sciences deals. But here we have two most common mechanisms that most of you are probably familiar with to determine the purchase price in a share deal. We will not go deeper into this or get too technical with this in the interest of time. So let's talk about payment of the purchase price. Here we make two big distinctions. You either pay everything at closing, or you pay in different installments spread over time. So you either pay 100 million at closing, or you pay like 20 million each time in a few years. So this is all in a context where the price is seen as fixed. It is also possible to determine a part of the purchase price that is variable. And here, a typical example that I put on slide here is an earnout. So it's actually a form of deferred payment, but it's not of the original purchase price. Parties here actually agree to pay an addition to the initial purchase price. And this is usually based on certain conditions, if on future performance or achievements that the business will have. And it turns out to be that earnouts are pretty common in life sciences deals, so we'll focus a little bit more on to that. So, as mentioned earlier, earnouts happen post-closing as an additional payment based on future financial, whether not financial, performance of the target company within a certain time period. Earnouts are useful to bridge the valuation gap that could exist between parties. It's not uncommon that parties have different expectations regarding the performance of the target. Just imagine a big pharmaceutical company player investing in a smaller biotech startup. Of course, startup is looking for funding, so it will do its best to convince the investor that its business will be successful in the future. So an earnout is then included to the SPA, and the seller will be rewarded if its predictions actually come true. But at the same time, it would protect the buyer from overpaying if this is not the case. So here we make the distinction that an earnout can be based on either financial targets or non-financial elements, which we will call milestones. Needless to say, life sciences deals, we see more that milestones are typically of greater importance than reaching certain financial targets. Examples such as the delivery of a certain product, advancements of the development of a drug. Do we go from phase 2 to phase 3 in a certain point of time, or acquiring certain regulatory approvals, or obtaining patents, and so on. So now certain points for attention when drafting earnouts. Of course, there are more things to consider than what is only mentioned on this slide, but here are some main highlights. So clear drafting is a must. Again, we must not forget that in Belgium, the purchase price must be determined or determinable. This is usually quite complicated if you set financial targets, because then we are dealing with complex formulas and examples of the calculations. So this could be a bit more complicated. Well, not to say that it's not complicated with milestones, but the earnout amount is usually fixed. But the focus here is more on the description of the exact circumstances that must occur in order to determine whether a milestone has been achieved. So another factor is after the transaction, once you set the milestones, you want the target company to be able to let the seller know where we stand in order to allow the seller to stay informed on the status of the ongoing developments. So usually reporting duties are put in place in the contract, so the parties will keep each other informed. As it is very factual and often subject to interpretation, you want be able to call upon experts once the parties do not agree on whether or not certain achievements or targets were achieved or reached. But of course, yeah, only in the event when parties cannot agree on this. When setting the conditions for obtaining an earnout payment, parties should also make sure that the satisfaction of the condition will not exclusively depend on the will of the party who covenants to achieve set results or milestones. For example, you cannot set a condition like, I will buy if I send you a letter the day after, because the choice to fulfill the condition is completely in your own hands. Or another example, milestone regarding a certain qualification standard that the drug has passed is achieved only if it's certified by some reporting issued by the target company itself, which is also seen as a not valid condition. So timing here is important too. Which financial year should the financial targets relate to, or how are achievement dates set? A bad example would be expectation that a certain drug is under clinical trial and will reach phase 2 normally in X amount of months. So you fix a date then, but in the end, it was achieved 5 months later. Then I'll have discussions. Oh, did we actually achieve or not achieve because it was not achieved timely? Obviously, it's not a good idea to use a fixed specific date. So usually the date is tied to when certain things are obtained or achieved. Hence, we call it an achievement date. So a bit more on milestone drafting. As you may understand now, it is very fact specific. Just a few more pointers, another example before we finish this part. Here I would like to highlight a case that was indeed from the United States, but nevertheless, as it was very factual, I do find it highly relevant. So in this case, the court ruled that earnout payments were not due because the milestones were not considered achieved. It was considered that a drug did not meet the standards of a certain study protocol, but yet the target company managed to push the drug through regulatory approvals despite it not meeting the standards that were stipulated in the SPA. So the study protocol, eventually the drug reached phase 3, even though the SPA mentioned that reaching phase 3 approval would be considered as achieving a milestone, but the condition was described in such a way that this is only acceptable if the drug also complied with the endpoint qualification set out in chosen study protocol in this particular case. So therefore, the court ruled that none of the milestones were actually achieved, as the regulatory aspects did not match the technical aspects as was drafted in the agreement. So it's definitely also recommended to have your intellectual property lawyers have a look at these kinds of descriptions too. So moving on to the later phase, the last phase of our webinar. Today, we talked a lot about share deals. So let's change the context for a bit and pay more attention to the asset deal context. The problem with asset deals is usually the implementation to have the assets transferred. For real estate, you have to go past notary. For IP, you have to perform certain registration updates. But very often we see in asset deals that the transfer of employees is usually a bit more tricky. So imagine you have grown out your business, your biotech business, and managed to expand, and multiple work streams and business divisions have been developed, and it's actually maybe time to sell or spin off one of these business divisions. So let's focus a bit more on this scenario. And for this, I will give the floor to my colleague, Mieke.
Thank you, Richard. Indeed, if we are talking about an asset deal, me as an employment lawyer will come up time and time again with the legislation on the so-called transfer of undertaking, internationally known as TUPE legislation, and in Belgium, the famous, or better yet, infamous collective bargaining agreement 32 bis. We are talking about a transfer of undertaking if there is a change of employer resulting from a transfer of an undertaking, which could be a company, a department within the company, a technical business unit, or only some part of a company, and this by virtue of an agreement between parties. This could therefore also mean mergers, demergers, or also, for example, the outsourcing of payroll activities, cleaning services to an external partner. So to be clear, a share deal will not include a typical transfer of undertaking, since there is in practice no change of employer. If the conditions for a transfer of undertaking are met, the collective bargaining agreement 32 bis stipulates that there is an automatic transfer of all employees who are in the scope of the transferred undertaking. It is therefore not possible as buying entity to just pick and choose which employee you want to transfer and which one you don't. The transferred employees are also all protected against dismissal. If the buyer does not want a certain employee, it is therefore also not possible to dismiss that certain employee after transfer. This could only be done by way of a dismissal for serious cause, so a serious fault of the employee, or for economic or technical reasons. It is not defined by law how long this protection against dismissal lasts, and there is also no sanction or indemnity stipulated into CBA 32 bis. A wrongfully dismissed employee could therefore claim all moral and material damages according to civil law. Seller and buyer will also have joint liability for social debts, but 1 hour is too short to go into detail. And there is also an information and consultation obligation towards the employee representatives. But the main consequence of a transfer of undertaking I would like to highlight today is the preservation of salary and working conditions of the transferred employees. The employment relationship is, because of the transfer of undertaking, transferred completely as is. This means with the salary, the length of service, the function of the employee, any entitlement to bonuses, a company car, and also any protection an employee might have, such as a protection against dismissal because of, for example, the mandate as an employee representative in the Works Council. I would therefore like to take the opportunity to remind you of the social elections in 2024. The protection against dismissal of the candidates for the social elections can already start on 14th of January 2024. So keep in mind the current protected employees, but also the new possible employee representatives. By same working conditions, I definitely mean also same working conditions, not similar, not equivalent. In practice, this is of course not always possible to maintain. Therefore, the buying entity will often negotiate individual or collective agreements with the concerned employees in order to have the possibility to change part of the salary package. By working conditions, I mean individual as well as collective working conditions. Therefore, for example, if the selling company has company collective bargaining agreements in place, which, for example, grant the right to cost allowances, benefits such as meal vouchers, bonuses, equity-based incentives, the right to a company car, these rights, these company CBAs, will also be transferred to the buying entity and will remain in force until the expiry date of that certain CBA. Company CBAs are also automatically incorporated into individual employment agreements, by which the benefits they would grant to the employees could also remain in force after the company CBA would have ended. To avoid this, we always recommend when drafting a company collective bargaining agreement to explicitly include the mentioning that any collective right from that CBA will not have direct incorporation, or in Dutch doorwerking, into the individual employment agreements. I have said that because of the transfer of undertaking, the employment relationship as is transferred, but in practice that is not entirely true. If a company would have tax rulings, for example, which define the right to give specific homework allowances, representation allowances, cost allowances for parking, small gifts, clothes, all free of taxes because that certain amount is approved upfront by the tax authorities, these tax rulings will not automatically transfer to the new entity. A tax ruling is specifically linked to a certain company, to a certain employer, and as soon as the entity changes, the employer changes, the tax rulings can, strictly speaking, no longer be applied to the concerned employees. Again, in practice, buying companies will keep granting the cost allowances as if the tax rulings are theirs, are transferred as well, but strictly speaking, there could be an issue during tax inspections. The same for work permits and single permits, the combination of a work permit and a residence permit. Those are also specifically linked to an employer. As soon as the employer changes, the work permits should, in principle, be renewed. However, since last year, 2022, the regional authorities responsible for the granting of work permits have indicated that it is not required anymore to go through the entire application process for new work permits in case of a transfer of undertaking under collective bargaining agreement 32 bis. To be clear, this is not a change in legislation, but merely a policy at the moment of the competent authorities in which they indicate that it suffices for the buying entity to just send them a letter by registered mail with a list of employees who currently have a work permit and to indicate on which date they will be transferred to a new entity, to the buying entity, and that they will take their work permits with them. As soon as the expiry date of those work permits has been reached, of course, the new entity will need to go through the application process of the renewal of the work permits, separate from any transfer of undertaking, of course. Also, a group insurance or a pension plan is not automatically transferred. When the employees are then safe and sound transferred to the buying entity, there are, of course, still a few post-closing matters to keep in mind. Just for the sake of completeness, we would like to remind you of a few examples. Corporate-wise, for example, Don't forget to make the UBO registration. IP-wise, make sure to record the change of ownership of registered IP. And employment-wise, kind reminder that the protection against dismissal is not limited in time, so it could be claimed by an employee within any moment after the dismissal. I then thank you very much for your attention and presence today. I would also want to take the opportunity to draw attention to other scheduled seminars and webinars at Altius, the digital law series, as well as the IP updates. And also all previous seminars and webinars are still available on our YouTube channel, so make sure to check that out. Then I would like to wish you a very nice day, and hopefully we will see you again on one of our other seminars.